Welcome everyone to the Issues Subcommittee to study regulatory change. I'm your chair, Mark Enriquez. Hard to believe that it's November 19th, just a week before Thanksgiving. I appreciate everyone joining us today. I do want to remind everyone it's the duty of committee members to avoid conflicts of interest and the appearance of conflict of interest as you perform your duties as a member of the Committee to Study Regulatory Change and your duties as a member of the North Carolina State Bar. If any member of the committee is aware of any conflict or appearance, they should disclose those at the meeting. Anybody have anything they need to disclose now? If not, we have one housekeeping item before we move to our main presentation. That's approval of the September 29th, 2020 minutes of the meeting. Those were circulated as part of the agenda that I think Brian sent around last week. Anybody have any changes, comments, or corrections to those minutes? If not, I'd entertain a motion to approve them.
I'll move to approve the minutes.
Thanks, Steve. Is there a second?
Second.
Great. All right, it's moved and seconded. Do you want to use our, I guess we can use our vote buttons, although this may be the only occasion to use those vote buttons. But if you don't remember, if you click on the participant tab, you can click your vote button so that we can have an official recorded vote on the contentious topic of minute approval.
It looks like that passes, Mark.
Looks like that passes. There we go. A little easier than some of the some of the recent ethics committee votes. So
right.
Yeah, we'll take what we can get on easy motions. So, as you recall, this has been a real learning exercise for the committee. We've learned about, different approaches taken in both different states and even some different countries. We've looked at things from a legal aid perspective. We've heard about technology changes. One of the issues that has been very interesting to learn about has been the idea of a regulatory sandbox. And that's really the topic that our guest, Lucy Rica, is going to talk to us today about. Lucy's the executive director of the Utah Supreme Court's Office of Legal Services Innovation. Interesting, because I don't really think we have an equivalent office in North Carolina. She's also a fellow at the Center on the Legal Profession at Stanford Law School. She did her undergrad work at Dartmouth and went to my alma mater, University of Virginia, Wahoo, for her law degree. She also worked as a paralegal at Williams and Conley, and then worked with Orrick Harrington, a big firm in San Francisco. She clerked in the Western District of Virginia. I clerked in the Eastern District of Virginia. And she's been a special project advisor for the University of Denver's Institute for Advancement of the American Legal System. I'm looking forward to hearing from Lucy because she's really, as you may recall from our earlier update, Utah has taken this regulatory sandbox idea and really tried to implement that. And if we're going to think of doing something like that in North Carolina, and that is one of the items that I think is worth very serious consideration by this committee, I wanted to hear from someone that's actually doing it and how it works and get, advice about what's involved, try to understand, both the motivation for it and some of the practicalities of doing it. So so Lucy's going to talk to us about that. And I hope following her presentation, to have some discussions, questions for Lucy, discussions among committee members and what it might look like to do something like a regulatory sandbox here. So with that, Lucy, thanks again for being with us, and I'll turn things over to you.
Sure. Well, thank you, Mark. I appreciate it. And I'm a Virginian by birth and upbringing and history. So I am super excited to speak to fellow Southeasterners, although I've been in California now for probably about 15 years. So anyway, but it's a pleasure to be with you all today. And thank you for having me. So you are right. North Carolina does not have an equivalent of the Office of Legal Services Innovation because no state really does. And we are brand new. We have been I guess, officially extant since the end of August. And we're the kind of outgrowth of the past two task forces that the Utah Supreme Court formed to study this issue of regulatory reform and think about how to implement it in the state of Utah. So I was on both of those task forces and had been working on this model previously. And Utah was just really ready to actually go ahead and implement something that, as you'll see, is really, really far reaching and has a lot of potential for sort of launching the legal profession. And beyond just the legal profession, I think launching legal services in the United States into kind of the next, I mean, some would say into the 20th century, but let's say the 21st century. So anyway, let me take you through it. So I'm going to start with a little bit of what drove the Utah Supreme Court to really jump with both feet into regulatory reform as a mechanism for increasing innovation and competition and access to justice in the legal services market in Utah. So here's, kind of the status quo, which you all are pretty familiar with, I think, but we know that the United States has one of the most restricted legal markets in the world, right? Our rules restrict almost everything about how the business and service of law is done, right? So we restrict who can provide legal services, who can invest in them, who can invent them, how they're paid for, how they're financed. Like, we really restrict that down basically to just lawyers. And it's these two mechanisms that are the primary drivers of these restrictions, right? So Rule 5.4, as you all know, says only lawyers can own and finance, basically, the practice of, entities that practice law. So we know lawyers can take loans from banks, but other than that, it's pretty restricted. There's not, we're not able to go into joint venture partnerships with non-lawyers. We're not able to have non-lawyer equity owners of our legal practices. We aren't allowed to take venture capital, all these kind of things. So we have a really narrow scope of who can own and finance legal businesses. Then on the other side, the unauthorized practice of law doctrines, although as we know, they are different state to state and pretty vague. The effect is essentially that in most states, practicing law is defined as anything that a lawyer does, and only lawyers are allowed to do it. And lawyers are not allowed to do it in corporate form, right? So we have a very broad definition of the practice of law, a very narrow definition of who can do it. And these two mechanisms have really served to kind of create a lot of dysfunction in the legal services market, particularly as our world has become so much more law thick. And this is a term that Gillian Hadfield uses that I think is just very evocative, right? We live in a law thick world. Law touches every aspect of most people's lives, in a variety of ways. And yet we've really restricted the types and the numbers of people who can help people navigate that law thick world. So this is kind of what has resulted. The US is really not doing great on the access to justice front. We rank 109th out of 128 countries on how the number of, or the percentage of people who can access and afford civil justice. These numbers are from the World Justice Project, which is a great organization. It was started by Bill Newcomb, who used to be the general counsel of Microsoft, and they've got a lot of great data on civil access to justice across the world. Sorry, I have to move all the faces around as I navigate these slides. So here's the market that we're dealing with, right? We know that about 80% of Americans don't get any help to solve their legal problems. That's crazy. And that's unconscionable, really, I think. In Utah, and this is, we had a justice gap that came out, I think it was about last spring, as we were working on our implementation of this regulatory reform. But in Utah, about 93% of parties in civil cases, not including juvenile cases, were unrepresented. And we know that for most Americans, the types of problems that we're talking about are what I think of as public health legal problems, right? They are problems that have really significant impacts on people's lives across a wide range of kind of metrics of quality of life, and they have a long tail in that they impact the communities that those people live in. Some of the best research on this is on the impact of evictions on communities where you see a lot of evictions, right? At the same time, I just want to be super clear, these public health legal problems and the legal problems that we know that most Americans are facing, they impact the very, very poor, you know, in a high frequency, but they also impact people all the way up the economic spectrum. When we're saying 80% of Americans, like, that's much bigger than those living at 120% or 100% of the poverty line, right? So thinking about access to justice, I think, obviously, you know, initially we kind of all go to those who need legal aid or who could qualify for legal aid, but we're talking about all the way up the spectrum, including, you know, folks that are potentially ourselves, like, you know, me paying a lawyer to do my estate planning. I don't really, that's a significant expense in my budget. So we're talking about a wide range of folks on the economic spectrum. So when I'm talking about access to justice, I'm talking a very broad definition of it. And I do, you know, this last line here, access to justice crisis is a crisis of our democracy. I really believe that. And Becky Sandifer's work, which I think I sent you all an article if you have a chance to take a look at it, her work really makes that tie very explicit. You know, when we're talking about this number of Americans for whom the justice system, the civil justice system, is just non-existent, we're talking about folks who are just not, they're not engaging with their legal rights in any sort of meaningful way. And that's a problem in a democratic society. So that's like from the public side, right? But this dysfunctional market really isn't good for lawyers either. And this piece of it, the provider side, is something that I think gets missed a lot in a lot of our conversations about this. We know the elite bar is doing okay. We know that folks that are working for firms like my old firm, Oric, or for, you know, the Williams and Connollys and the Wachtels of the world, they're doing okay. You know, they might be feeling a little pressure from some of these alternative legal providers, you know, but really, we've seen the profits per partner number. We know that the corporate bar is doing okay. Who's not doing okay are lawyers who serve people. And Bill Henderson wrote a report, I think you all have seen it, for the California task force a couple of years ago. I think it's now been like 3 years that he wrote the report, at least. The individual, he calls it the people law market, like lawyers who are serving regular people. Many of you may be on this call, may be in that bucket. That market is shrinking because people are just not using lawyers. And so Bill's figures are that market shrank by nearly $7 billion, or about 10%, between 2007 and 2012. That should be worrisome. And the other piece of that is that many of the lawyers who are serving this population, you know, regular people, it's a very inefficient model because of the way that we've structured the business, you know, the way that the rules have restricted the business. Lawyers have to do almost everything. And so a lot of these lawyers are just scraping by. In an 8-hour day, they're really only collecting, and this is data from Clio. I think it's 2017 data, but I haven't had the chance to update it. You know, they're really only collecting on about 1.6 hours in an 8-hour day. And you know, these are folks that, you know, we all went to law school. We all went with the goal of helping people, and they're spending a lot of time on other stuff as opposed to actually practicing law. So those are the two sides of kind of the status quo. The other big piece of this is that we know legal services, we've sort of seen the symptoms of what I just described are symptoms of this change. They are changing. They're moving from a one-to-one model, the traditional model that we're all familiar with, to a one-to-many model. So what does that mean? All of these different sort of trends, global trends, they're not just specific to legal, right? are impacting this change. We're seeing obviously the use of technology has really, really impacted this. The way people use technology to get services has really changed how people interact with professional services. The gig economy, globalization, obviously. We've seen a lot of alternatives to court, private alternatives pop up. And then obviously the pandemic has accelerated a lot of these trends. The rules were written for our old model, and they're not facilitating the change of this service. They're impeding it in a way that has created the dysfunction I described before. So this is sort of a picture of like the status quo in terms of how the market is looking right now, right? So we have the regulated universe, which we're all really familiar with, which is the state Supreme Courts regulate the bars, which regulate lawyers through, and traditional law firms through the lawyers, right? The only mechanism by which the bar is able to regulate firms is through the individual lawyer regulation. And then you've got everything else. So this is everything else is where a lot of people are actually accessing legal services. So you've got a lot of different startups. You've got a lot of different entities that are engaging in legal services in a variety of ways. We also know that a lot of folks are getting legal help and advice from folks in their community who are not lawyers. And these are trusted community leaders. These can be social workers and case managers, friends and family. And our system does not permit that. Other systems do permit that and have permitted it, for example, in the UK for years without any significant harm. So if this is the situation that we're facing, and on this side with all of the little logos and whatnot, I mean, this what I've put on here are a small smidgen of what's out there. So this is our situation. That to me says there's something really off about our system of regulation, right? We are not meeting the market where it is. And what's happening is that the market is leaving us behind. That's not good. Law is too important to have all of these services unregulated. So what can we do about that? And this was really what the Utah Supreme Court and our task forces, that's where we started, was how do we create a new system of regulation that promotes new business models and services and makes it attractive to those services and models to come into the regulatory environment? And how do we do it while we protect consumers? So this is really different from where we are now, really, really different. And it's extremely exciting. It's extremely difficult, but that's really what's driven the Utah reform, which I think gets missed a lot in the coverage of it, partly because the sandbox concept is just a piece of that. But anyway, I'll keep going. So what we have in Utah is really a new regulator. My office is a new regulator of legal services, and we have a new regulatory approach that is very, very different from the rules of professional conduct and the traditional disciplinary system. We have developed what we call, and it's not our words. I mean, these types of regulatory systems are used in other industries and in other geographic jurisdictions, but we have an objectives-based, risk-based regulatory system. So our new regulator has this regulatory objective. This is the goal that our system is supposed to meet, right? To ensure consumers have access to a well-developed, high-quality, innovative, affordable, and competitive market for legal services. That's our goal. So as we move forward, every regulatory decision that we make, every structure that we set up, every question that we're faced with, we go back to this objective, and we ask ourselves, how is this decision going to impact that objective? It's an incredible kind of discipline because it's so different from how we've done it before. Before we just said, well, does that kind of violate the rules or not, right? This is very different. Our regulatory principles guide our everyday implementation of the regulatory objectives. So, and you'll see that these are really different from our traditional approach, right? Our regulation, as we develop out our regulatory framework, we need to focus on being risk-based. We look at risk of consumer harm. We need to be empirical. We are first and foremost focused on gathering data on how consumers are impacted by legal services. Our regulatory mechanisms need to be proportional to that risk, right? So some risks are small and some risks are big, and we try to be flexible and responsive in that way. Our regulation has to be relative to the actual status quo, which is that 80% of Americans don't have access to legal services. So we're not measuring from the idea that every American has access to the best, Edward Bennett Williams or whoever for their legal help, right? We're measuring from the fact that most Americans are muddling through all by themselves. And so solutions are not going to be, they may be less of a lower quality than Edward Bennett Williams, but they're better than people muddling through by themselves. And that's kind of where we want to be. And market-based, we want the market to kind of drive a lot of this because consumers, there is an information gap in legal, but consumers know a lot more than we give them credit for. So on the bottom here, these are our three major risks that we've identified as like the highest priority risks to the regulatory objective. If our system allows these three harms to occur at a high level, then we are failing on our regulatory objectives. So these are really simple indicators of whether we're succeeding or failing. So the risk that a consumer gets wrong or bad legal help, the risk that a consumer fails to exercise a legal right, those are sort of competency and quality measures, right? And then the last one is the risk that a consumer buys an unnecessary or inappropriate legal service. That's upselling. Those three harms are what we are watching for in every service that we approve. Those are the three harms that we look at. We say, okay, what's the risk that this service might end up giving a consumer a bad result? And how is the entity proposing to mitigate that? And then what is the data that we will collect from that entity so that we can watch to see if it's happening? So here's what we have now in Utah. We have dual regulation of legal services. So the Utah State Bar continues. It exists. It's doing its thing. All the lawyers are still regulated through the bar. The Office of Legal Services Innovation, using risk-based regulation, is regulating non-traditional providers of legal services. There's obviously crossover there, right? Because one of the main pieces of this is that those non-traditional legal service entities can be non-lawyer owned entities hiring lawyers as employees, or lawyers can be owners of those non-traditional entities in partnership with non-lawyers. So what we have said is that any lawyer who's participating with an entity in this space, in the sandbox, can only do so as long as they can comply with all of their traditional professional duties, right? So the sandbox overall has waived 5.4, but every other rule still applies to lawyers participating unless they ask for some specific waiver, right? Okay, I'm sure there's gonna be questions about that, but we can come back. I'll keep going maybe. And do you guys want me to stop there and take questions? Anybody?
I guess I had, for the side that's not the bar, how do you address the unauthorized practice of law question? Is that part of the sandbox, or do you have any statutory issues? I know the Utah Supreme Court kind of adopted this structure, but I'm just wondering if there are issues for non-lawyer entities on that right-hand side, how the UPL issue is addressed, or is it just not, or is it an exception? How do you deal with that? That's
no. So yeah, so the sandbox explicitly contemplates UPL. So entities can apply to, but they have to explicitly say, as part of our model, we're going to have non-lawyers, providing limited legal advice, and they have to tell us how they're going to do that. And then if the court authorizes it, then it's a de facto sort of exception to UPL. And then we watch and see what happens. So yeah, it explicitly contemplates software provision of legal advice and non-lawyer provision of legal advice. So it's a sandbox both for UPL and for 5.4.
Okay.
Yeah.
Judy, can I ask a question, Lucy?
Sure.
Yeah, jump in. Go ahead,
What-
Steve.
When you bring someone into the sandbox, are there time limits set on that? Do you have markers as you go forward? Like to the question Mark just asked about UPL, you'd have sort of an exemption from UPL, but would that expire at a time certain, or would you address that in whatever it is that you whatever edict you put forward?
Yeah. So yes. So the initial authorization, each entity is authorized by a court order. So it's ultimately the court itself. We present to the court every 2 weeks, and we recommend, that slate of entities that we're recommending, and they have, it's still full. It's the final decision is fully in their discretion. But if they choose to authorize the entity, then they will issue an order that explicitly authorizes that entity, and the initial period is 24 months. And basically, that authorization is good as long as they aren't harming people. so then and I'll go through this in a sec, but each entity has to report to our office. And I'm going to go through what data they have to report, either on a quarterly or monthly basis. If we see evidence that they're harming people, and if it is not mitigated through our processes, if our regulatory interventions aren't working, and the harm is of a material level, then the court can pull the plug. They can suspend or terminate the authorization. If there's no evidence of harm, then the entity can apply to exit the sandbox. And the effect of that, they would still be regulated by the Office of Legal Services Innovation, assuming that we continue to exist, which is not totally, we're sort of a sandbox ourselves, right? But or a pilot ourselves. But if there's no evidence of material harm and they apply to exit the sandbox, their authorization would become a permanent licensure. They would still be subject to data reporting requirements and disclosure requirements and the regulatory oversight of the office, but it would no longer be a sort of temporary authorization. Should I keep
Colin, you had your hand up?
Yeah, I just wanted to ask, and you were touching on it there, but are these entities that are operating in the sandbox, are they licensed, or is their license essentially an order of the court? And if so, how does the court oversee and regulate and enforce their governance and their guidelines?
Yep. It is an order of the court for now. In the sandbox, it's based on an order of the court. The court oversees it through us. So the office is the regulator. The entities report their data to us, and we are then the kind of first line of intervention. Yeah, I think that basically answers your question. Mr. McCarley.
I just need to get this question out so I can pay attention to the rest of it. It feels to me like if we allow non-traditional legal service providers, what we're going to do is make a lot of legal services into commodities. And that the two things that could likely happen from that are that we'll damage those 1.6 hour a day lawyers, and we'll risk getting incomplete or bad or inadequate advice to consumers. Help me feel better about this.
Well, I think what I would say is 80% of Americans aren't using lawyers already. And so, and a lot of those folks, I think, are looking for commoditized legal services. They're using LegalZoom. They're using Rocket Lawyer. They're using Divorce Me. They want to be able to get the legal help that the limited legal help for their issue in the way that they want to do it. And they're not using lawyers already. So I think, it remains to be seen. None of us know what the future holds, but I don't think that those people law lawyers and the collecting on the 1.6 hours of their 8 hour a day they're serving a small population that is not the bulk of Americans who need help. So the second piece of that is it is my hope and belief that facilitating more entities to offer legal services and employ lawyers is going to lead to a lot of different practice options for lawyers that don't currently exist. And I think about it a lot. I mean, I really feel strongly about this. And I know that in the past, it's been like sort of a, what's the word? You know, a scary thing for a lot of folks. But, you know, I've spent a lot of time in far Southwest Virginia and in Western Virginia. And it would be wonderful to me if the Walmart in Lexington, Virginia could have lawyers, staff, attorneys helping people get a will, get a child custody order, you know, filed, helping them with these really simple unbundled legal problems where everybody is on Friday night, where they're already getting their optometry services, their prescriptions, they're getting limited medical services. You know, I really think that there are going to be a lot of options for lawyers in these new models that are really going to enable them to help people in a much more broad way. Another aspect of this, and this is actually, I can get to it in a sec, but you know, one of our first authorized entities in Utah is Rocket Lawyer. Rocket Lawyer, as you guys know, has a really robust platform for legal document completion. A lot of people use them. Millions of people use them, right, to get their basic legal documents done. Rocket Lawyer's authorization is to employ lawyers to supplement those legal services, so that he's the first lawyer in the whole country employed by a non-lawyer owned company. His name's Matt. And he is helping people who are, you know, trying to complete their documents, and they say, hey, I need help with this issue or that issue. Or I'd like advice on how to incorporate my company or what have you. So I think, you know, it's not a zero-sum game. I think we're going to see a lot more opportunities for lawyers in this, as well as non-lawyers, as well as software tools. The need is there. Like, the need is there. We're talking about a latent market that is enormous. So I feel really positive about the future for lawyers and the public in this kind of next phase of legal service delivery. I'm going to keep going, and then I'll pause again for questions.
Great.
Sorry, it always takes a second to, there we go. Okay. So I kind of went through this, but here's how our model works. It's very straightforward. And this is just at the front end, right? An entity applies, they tell us what they're proposing to do. We ask them to go through sort of a basic risk self-assessment, which is actually one of the harder things for everyone to do. It's really hard to look at your startup and say, well, here's how it could hurt people. But we kind of walk them through it, you know, and then we do our independent evaluation, and we've set out a kind of a risk, an initial risk assessment model that I'll talk about. And then we recommend it to the court. They decide whether or not to authorize it. And then based on kind of how we've categorized their risk level, they have specific disclosures that they have to make to consumers, and they have specific reporting requirements. So again, this is really different from how we regulate lawyers. There is much less on the front end. That can be very scary. But what you need to keep in mind is that the ongoing regulatory relationship is very intensive, which is not true for lawyers, right? For lawyers, we've got a high front bar, and then not too much afterwards. Whereas this is lower front bar, because we want to encourage innovative, different entities to apply. We don't want to have it be very expensive, but a pretty significant ongoing relationship. So these are the kind of data that entities have to provide. Again, this is really different. Lawyers don't have to do any of this, right? We don't have to tell anybody how our clients are impacted by what we're doing. These entities have to report at least on a quarterly basis most of them on a monthly basis, on these kinds of data at the case level. So for each consumer that comes to them, they have to tell us this type of data. And I'll go, whoops. Sorry, I thought I had a different slide in there. But anyway, consumer complaints, legal outcomes, which is like, if someone comes to you for a divorce, did they get a divorce? Financial outcomes, what was the settlement that they received? What was the fine that they were forced to pay? The amount the consumer paid for the legal service. And then now I can't see the bottom there. And the length of service. So, you know, how long did it take for them to get it? We also have, for some of our higher, you know, moderate and high risk entities, we have the ability, well, for many of them, they have to give us a kind of external audit of their files, not all of them, but we've asked for, you know, 20 of your cases in each kind of legal problem area. So we want to take a look at your first 20 divorce cases, and we're going to take a look at it for quality and accuracy. So is the software, you know, when presented with a set of facts, is the software making the right call on this stuff, right? Right now, there's nothing like this existing for any of those entities that I showed you on that slide up above, or for lawyers, right? So this is what we might be able to see, and I'm going to tell you a little bit about what we have seen as well. But traditional law firms and legal nonprofits with new service models, right? So having maybe the first tier of service is non-lawyer providers or software providers, and it's less expensive. And then, you know, either if a consumer is trapdoored out because their case is too complex, or if they ask for increased service, then they bumped up to tier 2. Legal tech startups, I mean, we've already got Rocket Lawyer, for example, and others like that. But these last two are the ones that I think, if we could get some of these in the sandbox and really offering services, I think then we're really seeing the potential for significant change. So new offerings by well-established companies. I already mentioned this. This one, I think, I mean, if we're talking about scalable opportunities, that would be amazing, right? If Fidelity already has a ton of, you know, estate planning services, if they could layer legal into that and hire lawyers to facilitate that, that would be amazing. Intuit, same thing. These kind of companies, the banks, I would love to see that. They would be subject to the same reporting requirements that the other entities are, so we would be able to watch for harm. But I would love to see these entities coming in. The problem is Utah's a very small state, so we need other states to jump on board too, hopefully. But this last one is to me the holy grail, and it's one of the hardest ones, I think. But we know that many community-based organizations that are not necessarily like legal aid orgs or legal services orgs are probably offering legal advice to people because that's where people go for help. So priests and other lay ministers, librarians, other workers organizations, social workers, case managers, like these are the folks who, if we know they're probably offering legal assistance and legal advice, we'd love to bring them out into the light and allow them to do it. And really build up this kind of community-based legal services tier, and particularly for disadvantaged populations and you know, the real indigent populations. This could be so significant. So yeah, that last one is the holy grail, but it's the hardest because we need funding and other help to, you know, these are already strapped organizations, right? Yeah, so this is where we are now. We have, I think, about 12 approved entities, and our very small staff of our organization, and we have a board, the Innovation Office Board, which is 11 members, including myself, and we have about, I think, 5 of those are non-lawyers, And so we've got, you know, a business professor from the University of Utah. We've got an accountant. We've got a kind of very influential businessman in the Utah community. And we meet every other week to go through applications. They review the applications, and then we decide whether to recommend them to the court. Here are some of the examples of entities that have been authorized to provide legal services. So I talked about Rocket Lawyer already. One Law and LawPal are sort of similar. They're chatbot/document completion tools now. Down the line, I think they're planning to offer a more robust suite of services, including non-lawyers. Law HQ is interesting. It's a plaintiff's firm in Utah that is building an app that goes on your phone, and when you get a spam call, you can swipe, and it automatically you kind of opt into a mass tort litigation, and it also gathers the the app itself gathers the evidence, right, directly from your phone to facilitate that litigation. Everybody loves this one. And it's, you know, I mean, the practice of law is no different in that model. It's still the lawyers are, you know, they enter into engagement letters with the clients and what have you. It's plain, you know, it's traditional lawyering, but they're going to take venture capital and that sort of thing. Blueby is a solo bankruptcy lawyer, and he wanted to give 10% equity to his longtime paralegal. So an AGS is a lawyer and a non-lawyer business consultant who advise dentists on forming and winding down their businesses. So, you know, these are a variety of risks. Blueby and AGS are low risk. They have less than 50% non-lawyer ownership. They have minimal reporting requirements, but we still watch for complaints. The other ones have more robust reporting requirements, including all of that information on outcomes and what have you. I think, yeah. The last piece of this is external evaluation. You know, we need robust external evaluation of what we're doing. We really hope it's great, but it's certainly different, right? But we need it. We need to see if what we're doing is making an impact. And we ourselves, as the regulator, are not looking at benefits. All the information that we are gathering is so that we can watch for harm. We are not looking to see how many more consumers are receiving legal services, or what types of services, or how specific populations are impacted. So our external evaluators need to do that. Our regulatory focus is solely on consumer protection and consumer harm. So we've got a variety of folks that are going to be conducting external evaluations of the sandbox. And I think that's the end of my presentation. That was a lot. So I would be happy to take questions, and just generally, I'm always available to talk on an individual, or I'll come back and talk to the group, whatever you all would like.
Thank you, Lucy. I think that was a really interesting presentation, and it's remarkable to me how much you've been able to do and kind of create, you know, a brand new structure, something that's unlike anything that's been done elsewhere. One question I had as you were talking is you talked about every couple of weeks presenting to the court the proposals and getting a court order. Is that, you know, the Chief Justice or a panel or the whole court? How do you actually do that? And how does the Utah Supreme Court have time? I guess I'm thinking of our judicial system. That seems like a big burden on them. And I wonder how you got them to commit to do that, or how you work that out. Well,
I've said this in almost every presentation I've made on this. The Utah is where it's at because of the leadership of the court, because they have owned this, and it's been a lot driven by Justice Simonis, but it's a 5-member court. All of the members of the court are very, very engaged in this, and involved. So when we present to the whole court every week, and they vote on each recommendation.
Wow.
Or, sorry, not every week, it's every other week. This is a lot of hard work. and it's been a lot of hard work by people who, for the most part, haven't been paid. I have been paid. I've managed to get funding from the University of Denver Law School, and now I'm obviously, you know, paid as the executive director. everyone else is pretty much volunteering their time. That's not sustainable. So, one of my big missions as the executive director is raising more money so we can have board stipends and that kind of thing, because again, law is too important to be dealt with on a volunteer basis, I really think. And so, so yes, so the leadership of the court and the ongoing hard work of the court, and also everybody involved in the project, has been completely game changing.
Great. I know Todd Brown, I think you've got your hand up. Go ahead, Todd.
Yes, I do. Lucy, thank you for that great presentation. It was very informative. And you've started to touch on just a question that I had, and it was more about the structure of your office and the resources available to you. And if I read your slide correctly, you sort of had the regulated side of the bar on the left side and everybody else on the right side. If you scale up as you would like to do, what sort of resources do you envision being needed to do effective oversight of all the non-traditional providers?
Yeah, it's a great question and a very good point. We have a small grant right now from the State Justice Institute, and hopefully have some more money forthcoming from foundational grants. The long-term plan is that we also we are not charging any of these entities right now in the sandbox context. But I don't know if any of you have had a chance to look at Arizona's structure. They have actually a fee structure that they've already put in place for ABSs who want to come into their regulatory scheme. We haven't done that yet. The long-term plan also is to charge licensing and renewal fees. I don't rely on those as able to meet our operational needs ultimately. It would be great if we were able to scale, if we had as many participants such that we could, but I'm not relying on those. So my first sort of strategy is foundational grants, and then going from there. But you're totally correct. If we scaled the way that I would love to scale, we're going to face money issues. And so that's kind of one of my first priorities. On the regulatory oversight piece, it's amazing. We have a data analyst, he's a PhD, and he, bringing the data in and analyzing it is not as complicated as it might seem. I mean, there's work to be done up front to make sure the data is not totally useless, because bad data in means bad data out. And lawyers have never had to report on this stuff before. So as we've seen with our first reports came in last month, and we got some work to do with kind of helping folks understand that, when we give you when we give you the code of what we expect you to report, you actually have to use that. You don't get to pick up your own. So we got a little work to do, but I think once, we get that up and running, and the licensing for the software, for the statistical software, is not that expensive. We've been able to bootstrap thus far, and I think we can continue to bootstrap at least for the next 2 years using foundational grants. And then from there, we'll see what happens.
One follow-up quickly. If I understood you correctly, the service providers report complaints to you directly. And my question is there any mechanism whereby the consumers themselves can report directly to you versus having the participants self-report? For example, lawyers get grievances filed against them all the time by the public. Do the consumers have the ability to come directly to your organization, for example, to complain about one of the participants that's been licensed by the Supreme Court?
Yes.
And if not, why not?
No, they can. They absolutely can. Yeah. Good. So the other thing that we've done is we've created, and we pulled this from the UK. They recently implemented this. We've created a badge that all authorized entities have to display prominently on their website, or if they have a brick and mortar, they have to display it prominently there, that says this entity is regulated by the Office of Legal Services Innovation. If you have a concern or question or complaint, here's where you go.
Thank you very much.
Well, but real quick, I would love to have more than that. You know, right now, all we can do is take in complaints as a data stream. We can't actually help facilitate individual redress of those complaints. The UK has a legal ombuds office that is separate from their frontline regulators that takes in complaints. And we know there's a wide variety to complaints, right? Like some of them are really, you know, just kind of basic customer service stuff. And some of them actually are about harm. The UK's legal ombuds office brings those in and then helps facilitate individual redress. They also have a compensation fund, you know, that's an errors and omissions compensation fund, very different from malpractice and very different from, what's the word for the fund that we have now? You know, when a lawyer steals money from their clients and then they can get money from the fund. We have one in California.
Client security fund is what we call it.
Thank you.
Yeah,
Sorry.
protection fund sometimes.
Yeah. So client security fund is very narrow, right? It's really about, you know, sort of fraudulence and stealing that the lawyer does. What I would love to have is something broader than that. That's an error and omissions fund, and that there could be some facilitation of individual redress. That's a little bit of a pipe dream right now because it would take a lot of resources, but I think the UK's model is very interesting. And if we were able to scale this and make it an intrastate endeavor, then potentially we could develop something like that to go alongside. And potentially it could be something that, you know, the ombuds could deal with lawyer complaints as well. It's just something to think about.
Okay.
Great. I know we have some more hands. I saw Barbara and then Jeff. Go ahead, Barbara.
Lucy, the question that Mac McCarley raised earlier, the concerns that he raised with you, are what we would hear, I think, from some of the lawyers. And I wondered, how did the lawyers in Utah, how receptive were they to this? And have you seen any change in that since the program's been implemented?
Yes. It's what you would expect. It is a challenge, and an ongoing challenge. The court leadership has made a really significant difference. The court is very, very committed and very committed to speaking, particularly Justice Himonas, speaking publicly to the bar and others about it. I think as we get, you know, all of our entities so far are still lawyer-driven solutions for the most part. And so I think as we see more of those, the opportunities will really become more sort of like, will kind of cohere a little more in people's minds, and they'll see that the opportunities are there. And as we bring in data on harms, these consumer protection concerns, hopefully we will be able to say, look, these aren't, you know, non-lawyer ownership is not, it's not undermining the profession. You know, we're seeing opportunities, we're seeing more services out there, and you know, there's not a lot you can do because I think a lot of it is driven by the unknown and fear, you know, and that I understand that, and I'm very empathetic with it. The only thing that I can do is say, we're bringing in data on a monthly basis. Let us watch and do our jobs and make sure consumers aren't hurt, and we're going to see what happens.
Thank you.
Jeff,
Thanks, Lucy. I think Jeff Summerlin Long, I saw your hand up as well.
Actually, you know, I had several questions, and the last two people have asked most of them. You know, I'm actually curious as to the response of the legal aid community. How have they responded to this, and have they been? Yeah, let's leave it at that.
In Utah, we have heard almost nothing. And I live and also am involved in the reform efforts in California. It is a very different situation in California. The legal aid community is very opposed to any reforms in California. And the arguments from legal aid are that this is going to establish a two-tiered justice system in which, you know, people who have money get lawyers and everybody else gets something else. The assumption being that something else is worse than lawyers. So my response to that is, hey, that already exists. Right now, we have a two-tiered justice system in which people with money get lawyers and everybody else gets absolutely nothing. And I really push back on the assumption that something else is worse than a lawyer. I don't think that the evidence supports that. And I think that people don't necessarily always want to go to lawyers. They want other solutions. And I don't think it's responsible to push that assumption as a given fact. So, you know, but in Utah, we really didn't hear from legal aid very much at all. And I don't, you know, I think that's probably, you know, sort of a different culture in Utah than it is in California.
Well, I mean, do they see you as competition for funding?
I think so, yeah. But, you know, I don't think that, you know, I don't think all of us in the innovation office, and, you know, when I speak to folks in California, and generally, you know, what we're doing with this regulatory reform is I really believe is a necessary piece to solving the access to, you know, these absolutely horrific access to justice numbers that we have in the United States. It's a necessary piece, but it is not a sufficient piece. So, you know, I will always say that legal aid needs more funding, and we need more legal aid lawyers, and we need more, you know, opportunity. We need more legal aid presence in communities across our country. But these two things don't have to be mutually exclusive. We can have both. We should have both. And so honestly, I also think too, you know, a lot of what we're talking about are solutions that legal aid could use to reach more people. You know, if you're able to have non-lawyers providing legal advice, and we know that like non-lawyers who are trained in specialized areas, for example, in eviction defense or in consumer debt defense, those people can really help a lot of people, and they can do it without you know, at a level of competency that is right there with lawyers. And so, and if we had software that could also be facilitating kind of simple unbundled legal services, that means that, and if legal aid can run those programs, that means they reach so many more people. So yeah, I hope that we can make some more inroads with the legal aid community and really get them to see the opportunities here.
Yeah. I mean, it is interesting because I used to be a legal aid attorney in North Carolina, and we had people who were not lawyers doing all kinds of work. And we just, you know, we trained them and then we trusted them. And then if there was actually a legal thing that we had to sign off on, we'd just sign off on it. And so I don't know. One of my concerns, I guess, is one of the hardest lessons I've learned in my life is that people who were trying to do good still compete. And I think that's something that we as a committee need to keep in mind, that you know, Lank, the Justice Center, legal services, whatever, are not going to be like, yay.
Yeah.
And I think we need them as allies. So, yeah. On a totally random note, I grew up in Roanoke.
Oh. I love Roanoke. It's a great city.
So, all right. Thank you.
Perfect. Thanks, Jeff. I think I saw Warren and then Mary.
Thank you so much. Lucy, first, I would offer and comment on Jeff's statement or question. You know, Goodwill and United Way live in the same communities all across America. And I'm sure one or the other was afraid when the second one arose. But I think the need is out there and it's going to outlast humanity. My question might be off the topic a little bit, but based on the examples you've given us, could you comment on the intersection of these new activities and malpractice insurance?
Yes, so we do not have a malpractice insurance requirement for any of these entities. Many of them are not, you know, well, sorry, let me go back. Utah lawyers do not have a malpractice insurance requirement. So it didn't really seem to make sense that these entities should have to have one. And we have, we have worked really hard in the sandbox and in this regulatory model not to build up a lot of requirements at the front end without knowing if they're necessary. Part of the reason that we are where we are is because we as a profession have made all of these assumptions about what is necessary to facilitate the ethical and high quality provision of legal services. And we've made it so ethical and high quality that most people aren't able to access it. So we've really taken a very different approach here. So there's no insurance requirements up front. As I think I said in the beginning, the only real requirement up front is that a disbarred or suspended lawyer cannot own more than 10% of any of these entities. That's really, I don't think I'm misstating when I say that's really it. So it's not to say that we wouldn't perhaps impose requirements down the line on specific entities if we felt it was necessary. And likely that would happen if we were seeing some evidence that consumers were not being served the way that we want, at the level that we of quality that we need. Yeah.
Thank you so much.
No problem.
Go ahead, Mary.
Sure. So Lucy, my name is Mary Irvine. I work with the IOLTA program here in North Carolina. And my question is going back to Jeff's comments, sort of as a follow-up, whether any legal aid programs have reached out so far to be a part of the sandbox with a particular program or initiative, because I mean, you sort of said this, but I think that there's a potential for the legal aid programs to actually be more efficient with some of their work, which would allow them to get and spend more time and attention on the cases that have the most merit that would require an attorney. But I think something that we also frequently talk about within our legal services community is the sort of triage function that legal aid can often provide, frankly, for the courts in some ways, by giving some limited basic information to individuals whose issues really don't, aren't going to be best addressed by filing something pro se in the court. And so I just wonder about those two things, whether some legal aid programs are looking at participating as a way to add to the services that they have available and to maybe make their services even more efficient.
Yeah, we have not had legal aid come in yet. We have, I think, and this is, so one of my sort of ancillary projects that I'm working on, and Becky Sandifer and I are working on together, is, I worry a lot about, with legal aid and then with other community-based organizations, that I just worry that they're not going to be able to make the leap because they're just overwhelmed already. And, this would really be about kind of developing out like a new service model and a new project, and you need funding, and you need time, and you need staff. And so what I've tried to do is encourage the University of Utah and the Utah Bar Foundation and Brigham Young University Law School to work together to start developing kind of a nonprofit incubator. Even if it's not an official sort of thing, just develop, like, can we start getting like foundations and funders lined up who are interested in funding legal aid to develop out a project like, that could come into the sandbox. And can we develop sort of consultants? I think we're getting a small grant that will help us, that will enable the Utah Bar Foundation to hire a consultant who could really specifically work with legal aid to say, okay, let's develop out a project where we're using non-lawyers in the sandbox, for example. We have, so I think our first nonprofit entity that came in is a partnership. She was authorized relatively recently. It's a partnership between Code for America, and a woman named Noella Sudbury, who has been really instrumental in Utah passing a Clean Slate Act that automatically expunges criminal records. And their project is about developing a software platform that proactively reaches out to potentially eligible people and then does a quick triage for them of whether they're eligible or not, and then directs them how to get their expungement papers filed. Down the line, she'd actually like the tool to like do all the paperwork for them. But right now it's really just about proactively reaching out and then saying, yes, you're eligible, or no, you're not. Which is great. I mean, apparently 1 in 4 Utahns are potentially eligible for this. So it's a huge number of people. And so that's the first in the legal services area that we've seen. I know there are others out there. I've had unofficial conversations with a lot of different people, but again, I think these hurdles of funding and time and resources are significant. And so that's why Becky and I are working on this kind of like, we wouldn't do it within the sandbox because we're just a regulator, but like I'm trying to get other entities to kind of build this out.
Great, thanks.
Colin?
Thanks. Lucy, it sounded like from your earlier comments that right now you're not measuring the additional legal services that are being provided to consumers. And how will we know what legal services or additional legal services we're providing to unserved consumers and be able to do some sort of cost benefit on that at some point?
Yeah, so like I said, we are the regulator itself, like the office is really only looking for harm. And so that's those 3 harm categories. That's all of our data is really focused on identifying whether or not those are occurring at material levels. It's those external evaluations. So ILES at the University of Denver, there's a couple of researchers at the University of Utah. All of these have, and then I think Harvard and Cornell, a variety of other academic researchers, their external evaluations, they're all different, but ILES, for example, I know is going to be looking at kind of the beneficial impacts and the access to justice impacts and which communities are being served by what services, and we're collecting data on the service areas. So, a lot of our data will be very helpful to their research. So we're collecting data on consumer service area, what is the legal problem that was presented, amount the customer paid. So all that kind of data will be very helpful for their evaluation. We're not looking at it though, or reporting on it with that benefit mindset. We're really just using that for harm. So they will do that other work.
I had a question, or a couple questions, Lucy. One is structurally, obviously the court is very involved in this, and you've told us how active your court is. What was the role of the bar, in particular the Utah State Bar, and kind of, who came up with the idea and structure? We're at an early stage in North Carolina, so this is a study committee, just trying to understand what other folks are doing. But I'm interested in terms of next steps, just how things actually got implemented and the relative role of the court, the bar, and how things were received, and how that went, and maybe any tips if we start taking the first step in that direction, what does it look like, or what kind of pitfalls may we want to know about or think about in that process?
Yeah. Well, it started, I think, it might have been about 3 years ago. I've really lost track of time with this whole pandemic, but I think it was about 3 years ago. The Jillian Hadfield presented at the Western Conference of Chief Justices, and I think it was the Western Conference. And Dino, Justice Simonis, was there with John Lund, who at the time was the president of the Utah State Bar, or the immediate past president. And they both were very impressed with Jillian's presentation. And read her book, which I highly recommend to all of you. It's called Rules for a Flat World. And it really, this Utah model is sort of taken straight from Jillian's head. I sent you all the article with authored by her and Deborah Rohde, straight from that.
Yeah,
and
that's
then,
in our materials, guys.
right.
If you haven't had a chance to look at it.
And so they then form the court, you know, as I said before, the Chief Justice and all the other members of the court were very supportive from the get-go, and they formed a task force. It's a very small task force, and also included Jillian, who, not besides being a law professor, is also an economist, and Dr. Tom Clark, who was the director of research at National Center for State Courts for years and is also an economist. And so having those economic perspectives and non-lawyer perspectives on the task force I can't underestimate how important they were, continuing to be, you know, like, because then we formed the implementation task force. Dr. Tom Clark continued to be on it. Jillian was on it, and Becky joined, and Becky Sandifer is not a lawyer. And, you know, she's a social scientist. So every time the lawyer brains, including mine and John, said, oh, well, we need to do this and we need to do that and they need to do this. And, you know, Becky and Tom said, but why? And we said, oh yeah, we don't have a good answer. So, and remind, you know, constantly reminding ourselves, the upfront piece is not the major piece here. It's that ongoing piece of data coming in and informing our regulatory policies and informing our regulatory actions. That ongoing regulatory relationship is that is where the rubber meets the road for this framework. And it really takes constant discipline to remind, particularly for lawyers, to remind ourselves of that. So yeah, I would say, like, on the Utah piece, I don't really know what's in the water in Utah, but I think part of it is that it's a small state, it's a Western state, it's a very pro-business state. And you know, they're very innovative. They have a huge they have a growing legal tech or tech community. Really significant companies there, including Qualtrics and others, and they're really open to kind of moving quickly on this type of stuff. But when I first started working on it, I was like, there's no bureaucracy in this state. What is going on? Whereas California is totally different. So anyway, it's been a lot of fun.
Great.
Lucy, can I ask a question? And you just touched on it. Could you talk to the participation by non-lawyers in your board? I think you said there was like 5 members of your board of the 11 are non-lawyers, and if you could kind of talk about their involvement, their perspective, how you've seen that play out thus far.
Yeah. Well, Becky and Tom are 2 of those, and so they've been involved for a while, and I sort of spoke to their perspectives, which is, you know, but why do we need to do these things that you say we need to do, which is very helpful, and also reminding us consistently that, you know, the way lawyers, you know, what's that old saying with if you have a hammer, everything's a nail? Quite applicable to lawyers. And so it's very helpful to have non-lawyers, and, you know, Becky and Tom are non-lawyers who have studied lawyers and the provision of legal services for their entire lives. I mean, Becky's a MacArthur Genius Grant recipient specifically for studying this issue. So having that really educated perspective from non-lawyers is very helpful. And then the others on the board are not necessarily, one's an academic. She's a business law professor at the University of Utah, and she studies AI and you know, AI-based systems. And so she's incredibly helpful when we get applications that purport, and I use that word purposefully, to use AI in their services. You know, this is very new for lawyers, and so you know, there are a lot of questions that have to be asked about how this is being provided. She's been great on that, and I think, you know, making sure that we're asking the right questions about the software. And then the other 2, really, you know, I think business folk think about services different than legal folk do, and think about oh wait, this company is going to make money this way. Really focusing in on that question of how is this company going to make money, and what is the risk in that proposal, in that kind of profit center. That's one of our main questions that we have to ask, and it's really, really, really helpful to have astute business folk weighing in on that.
So follow up on that, have you all rejected any applications, at least to the extent that you can talk about, to the folks that have applied to become a part of the sandbox? And if so, why?
Yeah, so not yet. It's mostly been, there's been several folks who have just kind of fallen off or withdrawn their applications. Not surprisingly, I think, not everybody understands exactly what it is. And so, or they, the disclosure requirements that we have really basic disclosure requirements around ownership, financial ownership and controlling ownership, and managerial stuff. And so I don't know why some folks have withdrawn. With the others, it's really, it's been mostly sort of, this actually isn't really what, what you're proposing. Actually, you can just do it. You don't need to be in the sandbox. It's already legal. I should say one other bar. I said that the disbarred lawyer was the only ban. That's not true. I misspoke. I knew there was something else. It was in the back of my head. The sandbox is not a way for out-of-state lawyers to come in and practice law in Utah. That we have also made clear. I think all of us know the criticisms of the jurisdictional practice rules. I would maybe have said that those folks could just be treated as non-lawyers in our risk model and let them do what they're going to do. But I think, it's not a battle that needs to be fought right now. And it makes sense, the jurisdictional requirements still stand. So that's the other major piece. Jeff, did you have another question? No? Okay.
Great. This has been a great discussion. Are there other questions for Lucy before we wrap up? I do think that you've given us a lot to think about, Lucy. I think it's a fascinating process. And, I know we'll be looking with interest to see how things emerge and the data that starts coming out of what you're doing. I think it's really interesting. So
thank you. Well, it's like I said, I sort of lucked into this project, and it's extremely challenging and hard brain work, but it's been a lot of fun. So and if anybody wants to reach out to me individually with questions, please feel free. I'm very happy to talk about this.
Todd has one. Go ahead, Todd. You're on mute. Todd, we can't hear you, Todd. There you go.
Okay, I'm off now. One question that Mark's comment brought up, are there going to be, for example, quarterly type reports that you will be issuing to the public that will be available for folks to follow along as to how things are unfolding? Or are you going to sort of issue a massive report at the end of the period?
So we have monthly reports that we make to the court, and I think we're just going to be turning part of that into a public report. Not all of it, because there's some pieces that, what we've said is once entities are authorized, then we make their recommendation and their authorization public. But while they're sort of in that deliberative phase of our review, we don't make it public. But I can send you all the first public report, which I believe should be up on our website, but our website is really terrible. I apologize. We're getting it rebuilt starting in December. So, but the plan is basically to take a part of that Supreme Court report and just turn it out and have monthly public reporting.
Okay, great. Thank you.
I just looked at the website and it said you could sign up for updates.
Yeah.
So I put my email in there. I don't know what you'll send, but.
Well, we are starting, what you probably will get, we have a little series of sort of educational presentations that we're doing in partnership with the University of Utah Law School. And so we're calling them the News You Can Use series. And they're sort of geared to folks who are thinking about applying, but not just. I think they'll be super useful for you all as well. So the next one, I think Arul, who is our business law professor, is going to be doing a couple presentations on AI, including quality audits of AI, algorithmic based services. So those will be really interesting, I think.
Excellent. Terrific. Anything else? I mean, as you know, the idea of creating a regulatory sandbox, I think, is one of several things we've heard about from several speakers. So I'm really glad we got a chance to actually talk to someone that is doing it, to see what it looks like, and appreciate everyone's participation and questions. And we can, we have a little time if you want more discussion on that now. We'll obviously be taking up this issue again as we kind of think about what might be a good fit for North Carolina. But this has been a good discussion and a lot of good information to digest.
Mark, I really want to know what Jeff's t-shirt says. I was like, I can't see the bottom of it.
It says, "I still hate Christian Leitner."
Oh.
You've got round applause for that one, Jeff.
Real quick, the regulatory reform, the piece in Utah, the new office is just one piece of what they have. So they also have a LPP program, which perhaps you're aware of. I think they just licensed their second class of LPPs. They also, which I think is really interesting, have all of their small claims are online dispute resolution. You have to opt out. And that, I think, is another, I love that piece of it. I think it's really, really interesting because, the reforming the rules side is one side. The other side is, as we know, court processes are a big problem. And the formalistic kind of approach of court processes is really, really a challenge. So tackling it from both sides, I think, is something to think about.
No, that's a great point. And definitely the idea of some limited license professionals, something I think we're going to be talking more about at a future meeting. And I'm interested, actually, your comment brings up a question that I think this committee's been wrestling with, which is kind of the pros and cons of just making rule changes. For example, just going in and changing 5.4 to eliminate the ownership requirement. The pros and cons of just making a rule change and kind of seeing what happens broadly versus a sandbox idea where we're going to eliminate some rules, but we're going to do it, and watch. And I think that's one of the things I think our committee is, grappling with. If you want to make a change, do you just change the rule and see what happens broadly? Do you do it in the context of a sandbox for monitoring? And I'd welcome any comments you have on that. But I think, we've thought about, those approaches, I think, as we're trying to consider. We've got a pretty broad charter to look at any possible change. So we're really looking broadly right now at what might be best for our state.
Right. I mean, I think it's sort of a difference between deregulation and re-regulation. What we're doing is re-regulation. It's certainly more market-based than where we were before, but it's not deregulation by any means. And what I really think about is, again, this idea that law is too important to be totally unregulated. And so the challenge of creating a regulatory system that really takes us to where we want to be in 50 years, that's what's so exciting about, I think, what I'm working on right now, is really not saying we're just going to get rid of this rule, but how can we create a regulatory framework that launches us and supports, the legal services industry into the next phase of our existence. So
great. No, that's a great distinction. All right. Well, I don't hear any other comments or questions, so we'll go ahead and wrap things up a little before required end time, but we haven't done that much. We've gobbled up 2 hours of everyone's time. So I'll give everybody half an hour back and enjoy the last frantic wrap up before the holidays. And I probably won't speak to many of you before the holidays. So have a good Thanksgiving. Be safe with all the folks that you're with, and look forward to getting us back together. I don't think we have one on our calendar yet, but we'll look at calendars and topics, and and have another meeting in the next month or so to continue to advance our learning and thought. So, and I certainly am looking forward to the time where we can do it together. I've been impressed by how much we've accomplished virtually, but maybe one day we'll actually sit around the table or raise a glass and actually be together, which would be nice as well. So thanks everybody for joining us. Thanks Lucy for wonderful information and getting us inspired to to put us on that 50-year path. I like that. I like that thinking. That's great.
Thank you.
Thank you all.
Thank you, Lucy.
Thanks everybody.
Thanks,
Happy
Mark.
holidays.
Thanks.
Thanks,
you.
everyone.
Great presentation.
All right.
Thank you.
So long, everybody.